Madame le Président.
Voilà, nous reprenons la séance.
All right, we continue the session. The minutes of yesterday's sitting are available. Any comments on them? No. So yesterday's minutes are now adopted. The agenda calls for a joint debate on the protection of individuals with regard to the processing of personal data. That's the Jan-Philipp Albrecht report, and then there's the Dimitris Drutsas report on the processing of personal data for the purposes of crime prevention. This is a joint debate, so to start with, I give the floor right away to the rapporteur who's just come in. 4 minutes, Mr. Albrecht.
Voilà. À vous la parole.
Dear Chair, dear Commissioner, dear Deputy Minister, dear colleagues. We are here to debate one of the most important legislative dossiers of this mandate. Thanks to the Lisbon Treaty, we are aiming to protect the fundamental right to data protection in a single EU-wide regulation. And thanks to this European Parliament, we have achieved an incredible goal of negotiating such a single EU data protection law on the basis of 4,000 amendments, including many aspects and views from all around the world. And we managed to get a position voted with the largest possible majority of the lead committee in October. Let me thank explicitly to the shadow rapporteurs Axel Voss, Dimitris Drutsas, Alexander Alvaro, Sarah Ludford, Timothy Kirkhope and Cornelia Ernst, the rapporteurs of the opinion committees, Sean Kelly, Lara Comi, Marielle Gallo and Nadja Hirsch, as well as our really hard-working staff. They all invested a lot of time and energy in negotiating this position and an agreement to be accepted. The wide consensus in the European Parliament on the importance of a high standard for personal data in the whole European Union and a more consistent application and enforcement shows that the European Parliament takes care of the citizens' concerns with regard to their fundamental right to data protection and their privacy in a digitalized world. If it would be only up to this House, we would already vote on the final regulation tomorrow to present the European voters a result. But more than 2 years after the Commission has proposed the draft regulation, there is still even no general approach by the Council. I am very pleased that this Council presidency has presented a timetable in January which is foreseeing to let this happen until July. But I also have a clear message to the Council. Any further postponement would be irresponsible. The citizens of Europe expect us to proceed to an adoption of a strong EU-wide data protection regulation. And if there are some member states which do not want to deliver after 2 years of negotiations, the majority should go ahead without them. After all what has happened during the last year, European citizens and European companies will not allow us to go on accepting that our European standards are constantly undermined by global big data business and third state authorities. As we as European Parliament can agree on a complex and comprehensive position, the Council of Ministers can agree as well. And there is an easy possibility for the ministers to agree very quickly. Just follow the position of the European Parliament, because all of the parties gathering in your governments have agreed to this compromise. Consumer associations as well as European enterprises are urging us to conclude the EU data protection regulation as soon as possible, because they all know that the only ones who will profit from this law being postponed and postponed will be the big data companies from Silicon Valley, who are constantly trying to evade EU market rules and thereby getting competitive advantages against the EU IT companies. And now we can see that more and more citizens are searching for data protection friendly products and services which they can trust. The governments of the European Union now need to show political will to send the message that systems, products and services in Europe have a gold standard when it comes to data protection. Thank you very much.
Merci, Monsieur le rapporteur.
Thank you, Rapporteur. I'd now like to give the floor to our second Rapporteur, Mr. Droussas, 4 minutes.
Micro.
Thank you very much, Madam Chairman. May I also start by thanking everybody having worked so hard in the past 2 years on this dossier. Without this incredible engagement of everybody, we would not have been able to be here today and voting in plenary tomorrow on the data protection package, thus sending to the European citizens the message that the European Parliament is aware of their concerns, that we are taking them very seriously, that the European Parliament is working for the interests of the European citizens. May I also thank the Commission and Commissioner Reding and her entire team for their engagement, their work and good cooperation we enjoyed working on this file. My appreciation goes also to the Greek presidency. I know of and recognise the efforts that the presidency is putting on this file, but the presidency will allow me to also express my dissatisfaction and frustration about the fact that it is the Council and at least some Member States who are the reason that we will not be able to reach the goal that we had set, namely to have the data protection reform package passed by the end of this Parliament's mandate. I doubt that the governments concerned will be able to find the necessary explanation to the citizens in their respective countries, particularly in view of the upcoming elections to the European Parliament. Madam Chairman, the European Parliament has for years been calling for a comprehensive single instrument on data protection that would cover both the private and the public sector, including the police and judicial cooperation in criminal matters. This is why this Parliament has always regarded right from the beginning the proposed regulation and directive as a package, what we call the package approach, and all our legislative work on the data protection reform has been conducted exactly on this premise. And let me remind everybody that there was widespread agreement on this already before the 2 legislative proposals were issued. It was the report of Axel Voss back in 2010 which stressed the idea of a comprehensive and consistent approach, also covering processing in the areas of police and judicial cooperation, including processing at domestic level. As a consequence, parallel procedures were followed by us in our works as regards timing and content of regulation and directive, and both me and Jan Albrecht and also the Commission, as repeatedly stated by Commissioner Reding, confirmed this commitment to the package approach several times. I do not need to elaborate on the regulation. Jan Albrecht already has presented the necessary facts that I fully endorse, and Jan, thank you once again for all the work and commitment you and your team have put into this file. The directive itself, if approved tomorrow, will bring significant improvements to the processing of personal data by police and judicial authorities in criminal matters. But, Madam Chairman, let me be very frank and very direct. It has come to my knowledge that a number of colleagues have decided to vote against the directive tomorrow. Colleagues, how exactly will you justify to your voters that you choose to protect them against, for example, Google, but not against police and judicial authorities that tend to act arbitrarily? How can one explain to the European citizens that we will vote in favour of the NSA report tomorrow, which reproaches a third country for the hidden action of the secret services, and we as European Union member states refuse to comply with similar rules? And how will you explain that, in case the directive is not adopted by the European Parliament tomorrow, it will be the European Parliament itself that will have abandoned the package approach, and we will have killed the directive, doing the dirty job that some governments of some member states wish to do so much? So, Madam Chairman, I finish with an appeal to colleagues to do exactly that, showing to the European citizen that we are taking his fundamental rights serious by voting in favour of both legislative instruments tomorrow so that it can be negotiated with the European Council as a whole during the next legislature. Thank you, Madam Chairman.
Merci, Monsieur.
Thank you very much, Mr. Troutsas. And now, Mr. Koukoulas, on behalf of the Council.
President, honourable members, tomorrow this House will be voting on the reports of Mr. Albrecht and Mr. Troutsas on the comprehensive data protection package which was proposed by the Commission in January 2012. This package comprises two legislative proposals. The first is a general data protection regulation which is intended to replace the 1995 Directive. The second is a directive on the protection of individuals with regard to the processing of personal data by competent authorities for the purpose of prevention.
Il y a un problème de traduction?
A problem with translation, apparently. Somebody not hearing the French?
Peut parler en français?
Attendez, non, on va voir, voilà, on va...
No. Have a go again, Minister. Okay, back to you.
I was saying that the directive, the second is a directive on the protection of individuals with regard to the processing of personal data by competent authorities for the purposes of prevention, investigation, detection or prosecution of criminal offences or the execution of criminal penalties and the free movement of such data. This is intended to replace the 2008 Data Protection Framework Decision. The Council has welcomed these two proposals and has on several occasions publicly pledged its broad support for them. Like the Parliament, the Council is entirely convinced of the need to update and modernise the Union's data protection legislation in the light of the significant technological changes that have occurred since the adoption of the 1995 Directive. Over the past 2 years, no other legislative file in the area of justice and home affairs area has been the subject of such intense discussions in the Council. In 2013 alone, almost 50 days of meetings of the relevant working groups were devoted to the discussion of these two proposals. And the Greek Presidency had already devoted over 10 days of meetings of the Working Party to this package. However, there is no hiding the fact that the Council has not been able to make as much progress as you have done. And I am aware that this is a source of some frustration, as the honourable member Mr. Troutsas just mentioned. The Commission chose to propose a regulation rather than a directive to replace the current 95 Directive. The Commission had good reasons why it made this choice. I am well aware that the Parliament is also in favour of the increased harmonisation which could be brought by the regulation. The discussion on the regulation is very work intensive. This is the biggest, most ambitious piece of draft legislation in the justice area during the term of this Parliament, covering all companies, public authorities and individuals in the EU. This implies detailed scrutiny by 28 Member States. This shows the great interest of Member States, which have detailed consultations at home with several ministries involved. Experts from all 28 Member States are working to ensure that the result of the negotiation is a high quality legislative instrument. Furthermore, data protection is a cross cutting issue which touches on almost every area of life and society. This means that the implementation of the 95 Directive affects almost every area of society and a large number of different legislative acts at the national level. The Greek Presidency is committed to broker this file, which is, as you know, a key element for both the individual rights and growth in the EU. This file is of crucial importance for the digital internal market, as highlighted by the European Council. I would like also to remind you of the conclusions of the European Council October 2013 on digital economy regarding the timely adoption of a strong EU general data protection framework and the Cybersecurity Directive as essential for the completion of the digital single market by 2015. During the Justice and Home Affairs Council of last week, Member States confirmed their broad support on the territorial scope and the understanding on the key principles of international transfers, this is Chapter 5, in line with the position already expressed in the January informal meeting of ministers in Athens. Progress was also made on key provisions of Chapters 1 to 4, namely pseudonymation, portability of personal data, obligations of controllers and processors, as well as profiling. These are essential for the digital internal market. If on top of this you take into account some very specific provisions on data protection in the public sector, such as legislation on social benefits, pensions, youth welfare and public health, you will appreciate that this is an area of a very great complexity. Furthermore, these provisions are often intrinsically tied up with the institutional, administrative and even constitutional arrangements within each member state. Our aim is to have a high-quality legislative instrument which is able to protect the personal data of our citizens and which can be applied in all member states. I am confident that once our internal negotiation process is over, it will be possible for both our institutions to find common ground on these proposals and have the two instruments adopted. I would like to take this opportunity to support this Parliament's view that the data protection reform should also apply in the future to the EU institutions. Last June, Vice President Reding gave a commitment that the Commission would bring forward such a proposal. President, honourable members, I would like to assure you that the Council, like the Parliament, attaches considerable importance to this reform. I would like also to thank the Commission and personally Vice President Reding for her dedication and engagement in this file. The Hellenic Presidency will make every effort to contribute in finalising the negotiations between the Member States as soon as possible so that we could begin discussions with the Parliament. Thank you very much.
Kourkoulas, la parole est maintenant à Madame.
Thank you very much. Mrs. Redding now has the floor.
President. I would like first to say a personal word to the rapporteurs, to the shadow rapporteurs and to all their collaborators. You have been extraordinary during the last 2 years and in the preparatory years before. And I think that through your work you have really shown that the European Parliament is a strong voice for citizens and for the economic development and for the preservation of our common values. So thank you for having done that, and vous avez bien mérité de notre Europe. President, in May 2011, this House called for a reform of the European data protection rules. The Commission delivered the proposals requested by the Parliament in January 2012, a package as had been asked in the Parliament's resolution by your colleague Voss. Now it is time again for this House to act. Now it is the moment that the European Parliament has the possibility to make the reform irreversible, to show to the world outside that the European citizens' concerns have been heard, to give European businesses a single market in personal data protection so that there are no more barriers anymore and that there is legal certainty. So this vote will be an important part of the legacy of this legislation, a test of its willingness to fight for Europe's values. I welcome the level of ambition of the report, which matches and sometimes exceeds what the Commission has proposed. I welcome the fact that the European Parliament has managed to work on the two reports in parallel and presenting it to the vote tomorrow as a package of revised rules. That is very important, and that answers clearly to the Voss resolution. The Commission and the European Parliament agree on the pillars of this reform. There has been a strong endorsement of the choice of legal instrument, the regulation, a single law for the whole of Europe. We must do away with the current directive, which has resulted in a patchwork, 28 national rules that make life complicated, costly for companies. The savings for companies by doing away with this patchwork are 2.3 billion per year. So only this is really an action for SME preservation. The level playing field will also allow the European digital industry to compete globally. Non-European companies, when offering services to Europeans, will have to apply European rules, adhere to the same levels of protection of personal data. This is about creating a level playing field between European and non-European businesses. This is about fair competition in a globalised world. The proposals of the European Parliament will also put individuals back in control of their own personal data by updating their rights. Explicit consent, right to be forgotten, the right to data portability, the right to be informed of personal data breaches, all important elements. And these important elements will help to close the rift which exists today between citizens and the companies with which they share their data willingly or otherwise. They will bring back the trust which has been lost. The benefits for businesses and citizens alike as regards the one-stop shop mechanism are also confirmed. Companies will only have to deal with one single supervisory authority, which will be the one in the country of main establishment of the business, rather than with 28 different authorities. This will make it easier, simpler, cheaper for companies to do business in the EU and to build this digital economy, which everybody agrees that we need. Also, this consistent application of EU law will make it easier, swifter and more efficient for individuals to defend themselves, to be protected, to get their complaints treated swiftly and on the basis of a coherent and strong protection mechanism. Finally, if companies do not play by the rules, as is the case very often today, European regulators will be equipped with strong enforcement powers. The rules will give them teeth. They will be able to fine the companies which do not comply with EU rules, up to 5% of global annual turnover. The Commission proposed 2%. Well, let's go for 5% if the Parliament wants so. It will be a deterrent. It will allow our regulators to apply the law, what they unfortunately cannot really do today. These are the very practical, very concrete ways in which the reform will help rebuild citizens' trust in the digital economy, will help the European businesses to exploit the digital single market to its full potential. Europe must act decisively to establish a robust data protection framework. And yes, Mr. President, I am impressed by the way the Greek presidency has taken this dossier in hand. Finally, somebody is leading this dossier after the Irish presidency had done a very good work. We had gone to hibernation. Now spring is back in the Council. Let's hope that this spring will lead us to a summer decision. Tomorrow's vote, dear parliamentarians, is a crucial step along the way. The Parliament will make this reform irreversible. These citizens will say thank you to the Parliament.
Merci, Madame.
Thank you, Commissioner. And thank you for your speech, and my thanks to the rapporteurs for the work they have done. Next speaker is Mrs. Hirsch on behalf of the Employment and Social Affairs Committee. Thank you very much, President. As Liberals, of course, we welcome a basic regulation in the area of data protection for Europe. And the committee, in voting in favour of these reports, has taken a step forward and has taken a step forward in protecting the rights of employees far, far better. We are against employees being monitored in the workplace using computers. And I'm pleased that the Germans have begun to stop their blocking action here. We can't have citizens involved in the use of digital data at the same time that data being used to spy on them and monitor what they're doing. So we have to be active here to make sure that the consumer knows exactly whatever data they put into the mobile phone or into the computer or into some device in their car, they are in control of what happens to that data. That is our objective. Mr. Kelly, on behalf of the Industry Committee.
Thank you very much, Madam President. I have 1 minute to summarise 2 years' work, so let's not waste time. So I'll make 3 positive points, 3 reservations. One, the point that we want one set of rules, a regulation across the entire European Union makes absolute sense. Any dilution of that would not make sense in an online world that knows no borders. I very much welcome the protection of children in the online world through permission from their parents or guardians for the processing of their data. 2, the trust of citizens will be increased by explicit consent and strengthening the right to be forgotten. And, as the Commissioner said, the one-stop shop will certainly be good for business across Europe. My reservations: 1, SMEs, 2, health research, and 3, press freedom. I hope that we can deal with those 3 issues in a more practical manner, because there is no point talking about the importance of SMEs if we have more regulation, no point talking about the importance of health research if we make it more difficult for them to do that, and also no point talking about press freedom if we inhibit them as well. Thank you very much.
Merci, Monsieur Kelly.
Thank you, Mr. Kelly. Mrs. Comey, on behalf of the Internal Market and Consumer Committee.
Sì, grazie, Presidente.
Thank you, Madam President. Sincerely, I'm not satisfied with this proposed directive. We could have improved the text, but it's not bad as it stands, but perhaps a more aggressive approach would have been better. We have seen how many young people use apps on their phones, and even if they just glance at them, they still generate data that can be monitored, that can be used. So the idea of this is something that needs to be taken into account. Also, micro companies. We need to have more sensitivity with regard to the problems that they face. In terms of the internal market, that's one thing, but the IMCO amendments on consistency have not led to a principle that is against the one-stop shop. That is something that could actually be seen very favourably. We need to ensure that the data is used with legitimate authority.
Merci, Madame.
Mrs. Thank you very much, Madam President.
à la circulation des données et
In this day and age, there is no border for freedom of movement of data. Data can easily be transferred to a third country and may be intercepted by surveillance bodies. As far as the international level is concerned, the European Union must now come to an agreement with the United States of America. We must reach an agreement in order to avoid mutual spying. We also need to look at the Safe Harbour Agreement, revisit that in order to shore up citizens' rights, and look at the way in which this is being used by companies and also by the US authorities. And finally, it seems to me that there is high time for us to really develop our potential, develop cloud computing, a form of cloud computing that would be genuinely European in nature. Concerning the personal data regulation matter, I very much hope that it will be adopted soon, so as to improve the protection of each and every one of us. That being said, we must not forget that this text would be applicable not only to the US net giants, it would also be applicable to all companies, European startups, etc., etc. So let's make sure that we are well informed. Let's not have all sorts of delusions about data. Let's make sure that we act in a way that is good for our economy, for research and for health.
Thank you, Mrs. Gallo. And Mr. Voss, also from the Legal Affairs Committee. Thank you, President. As regards the EPP, we believe we need the data protection regulation for Europe. We need a modern structure, and above all, we need the new rules to be properly implemented, because the citizens need more certainty as regards the fate of their data and more control of their data, and people have to have legal certainty when it comes to investing in Europe. So we need this data protection regulation very quickly, and therefore I appeal to the Council of Ministers to work on this very quickly so that we can make progress in this area as quickly as possible. And what we also need are now rules on our common effort to prevent crime. Personal data, of course, needs a different data protection structure from the kind of structures we have for processing personal data for the purposes of crime prevention. So if we could take the legislation from 2008 and then comprise this in the directive, that would also be very welcome. And now group speakers, Mrs. Gall now for 1.5 minutes.
Thank you very much, Madam President, Madam Commissioner. In this day and age, everything that we do, whether we're using the telephone, whether we're using a credit card, whether we're sending an email, whether we're using public websites, all of that is done through the internet. And our personal data, of course, is shared. That is why it's so important for us to adopt this new regulation, because we need to be up to speed, in tune with our age. We need to make sure that possibilities are opened up for us, but that there is no abuse. I remember a time way back when we were fighting for some other rights, for instance, the right not to be spied upon, for people not to have access to our data. Now, of course, a generation or two later, we know that all of this is being done by authorities. We know that personal data is actually being shared quite broadly, and citizens are not always aware of the fact. There is a right to protection of your personal data. They're not aware of that. Unfortunately, we have little awareness of this. The right to delete your data, to rectify your data, and so on and so forth. I think it's in all of our interest to make sure that we have a system that is good, that is feasible, that really is practical for people to use. We want to make sure that our personal data is protected well, but at the same time we don't want to make things impossible for our small and medium-sized enterprises, and we want to make sure that member states can also take part in good standards and defend the same high standards for data protection.
Thank you, Mrs. Gall. Mrs. Guillaume now for 1.5 minutes. I'd like to congratulate the rapporteurs and everybody who've been involved in the last 2 years in working on this package, which of course is going to be very important for the personal data protection of our fellow citizens. We have to defend people against abuses given the rapid development of the digital world these days. I believe that these two texts take us in the right direction. We shall have greater protection for personal data, greater support for citizens seeking to have the data removed or processed. Also, the way we deal with the question of transferring data from the EU to third countries. There, we are setting a sound set of foundations for future cooperation in this area. We now, I believe, have, after 2.5 years' work, a balanced text ready to face the challenges of the digital world, despite the great difficulties caused for us by the American digital giants on the internet. As regards transfer and retention of personal data, there again we have made progress and made it possible for citizens to take legal action to protect or have their data removed from sites that they do not want it kept on. I would call on the Member States not to postpone the adoption of these texts in national legislation. These texts must be implemented quickly so that we can all enjoy protection against abuse. Mrs. Ludford, 2 minutes.
I think it's a real achievement for the European Parliament to adopt its position on the regulation before the end of the mandate. So we're one step closer to securing reform to guarantee one set of substantive privacy rights across Europe. And I thank Jan Albrecht as the rapporteur for his very energetic steering of our work. We had our few battles, but I think we all stayed friends. I'm sorry that my ALDE colleague Alex Alvaro can't be here as he's unwell, but I, as shadow rapporteur, built on his work and that of his staff. And as Liberals, we sought to implement our belief that it's possible to have a synthesis of high data protection standards and support for innovation and jobs in the digital economy. And our aim throughout was to secure a text which is balanced, giving citizens greater control over how their data is used and by whom, whilst facilitating technological advances. Because smart companies know that their business will only prosper on the basis of trust. And it will be essential to have a robust compliance regime and strict enforcement, because otherwise those companies that do play by the rules will lose out. I'm pleased that my colleague Simon Hughes, who is the UK Justice Minister, has announced that the UK Government is reviewing the sanctions for breach of privacy under the existing directive. I'm glad that we put back the so-called anti-Pfizer clause to protect our citizens against court orders in third countries, and I'm still rather shocked that the Commission dropped this provision from its published draft. I mentioned trust, and a challenge dear to my heart is to safeguard privacy for health data whilst facilitating valuable research, but that needs the public to have confidence in what is happening, foreseeability, belief that there are strong safeguards and strict sanctions. And I regret the fiasco of the UK implementation of a project called Care Data, which has had to be delayed because it's a very poor management which is losing citizens' trust in this area.
Merci, Madame. Thank you very much, Mrs. Ludford. Mrs. Sargentini is next.
Dank u, voorzitter.
Thank you, Madam President. The proposal put forward by Jan Albrecht is something that is very important, and it also ties in with the directive and the regulation as well. We need to ensure that we have absolute security when we're transferring data to the US. Certain companies do not adhere to the rules and regulations in the USA, and we do nothing about it. We have got to be put on an equal footing with the USA. We've got to take action speedily now. We really do need to take action to ensure that Google and Facebook do not gain absolute carte blanche to do what they like. We want to ensure that European companies can be the safest in the world. We want to give them the opportunity to do that, to be able to offer services that everyone finds interesting, but they're also safe. And that's why we also need to ensure that all our citizens get protection as quickly as possible. That's why we're so hasty.
Thank you. Would you accept a blue card from Mrs. Ticau? Mrs. Ticau in that case.
Thank you, President. I would like to ask Mrs. Sargentini. Well, you mentioned the transfer of European citizens' data towards third countries. What do you think about the need to review the international agreements the Union signed with third countries and which regard the transfer of personal data, such as the SWIFT agreement or the national or the passenger name record agreement, so that these agreements should also fit with the new regulation that we are about to adopt? What do you think about that?
Madam President, I'd like to thank my colleague for that question because she's put her finger on a very important point here. The Greens, it's not for nothing that the Greens have been fighting against SWIFT and PNR's passenger name records. We've voted against that for years now. It's not for nothing that we've done that. We find it's a great shame that Mrs. Reding is trying to negotiate a law based on principle, on data protection namely, but it's not working because she is taking a very fragmented approach. And SWIFT, PNR, all of these things have got to be part and parcel of this. We've got to deal with this at the same time. We don't want to just protect ourselves against the USA, but the Russians and the Chinese as well. What do we do if they come up with this kind of proposal?
Thank you, Mrs. Sargentini. Next speaker, Mr. Kirkhope, for a minute and a half.
President, Commissioner, data is the lifeblood of modern society. It powers every new piece of technology, every new innovation. It powers manufacturing, social media and what we buy online. Our history, opinions and personal information are increasingly shared, exchanged and profited from. However, with progress and profits must come protection. Businesses, consumers and the individual are currently contending with 28 different legal regimes, different systems and different mechanisms for appeal and duress. A new era of technology requires a new era of data protection law. I believe we can now take a step forward in the completion of the single market, the digital economy and help attract investment into the EU. But we must apply common sense. We cannot place the same levels of burdens and administration on local small businesses on a par with multinational companies which deal with massive amounts of personal information. We do not want to deter those scientists and researchers who are finding new cures for terrible diseases and ailments every day. We must not scare off foreign investment in the EU by setting impossible standards. I do not agree with some of the proposals which the European Commission has made, however. I believe that the final compromise between political groups has, however, signalled the start of finding a proportionate and a workable way forward, and I commend the general approach to this House. Thank you.
Thank you very much, Mr. Kirkhope. And the next speaker, Mrs. Ernst.
Ja, vielen Dank.
Thank you very much. Data is something that's very important to the 21st century, and this data protection package is something to do with the shaping and guarantee of a fundamental right for everybody in the EU. Now, this fundamental right includes protection of the right to an undisturbed private life, privacy, and also fulfilling one's own desires without any impediment. Now, this is a fundamental right that if we don't ensure it, people cannot take charge of their own destiny and be as sovereign beings, and that's why we've put forward this data protection package. It is basically ensuring fundamental rights in the data protection sphere, and hopefully in the next few years it will meet the expectations and requirements that we will have. It will be future-proof. Now the Council has got to take the ball. Now it's in its court. It's been paying lip service to this idea of better data protection, but it hasn't actually done anything yet.
Mr. Batten is not here, so Mr. Zelstra is the next speaker. 2 minutes. The floor is yours.
Ja, voorzitter, dank u wel.
Thank you, Madam President. Now, today we're talking about personal data in the digital world. This is a world that is shaping our daily lives more and more. You've got the social media, emails, but online shops, your telephone provider, even your DVD player. They show your behavior. Your behavior can be traced in all of these cases, and that means that it has consequences for the rest of your life. It is not responsible behavior at all to allow this to happen. Sometimes consent can be given, but it doesn't happen all the time. sometimes people would not give their consent if they knew exactly what was going to happen to these data. There's this idea of e-call. That initiative has recently been approved. It ensures safety in cars. You're monitored all the time on what you're doing in the car. What about if you're in a company? Are you going to be monitored all the time in the interest of safety? I mean, in this digital world, we do need to ensure that privacy is guaranteed. There should be enough time to do this. I mean, this directive is only the start. It's the tip of the iceberg.
Thank you, Mr. Zelstra. Next speaker, Mr. van der Kamp.
Mevrouw de voorzitter, dank u.
Thank you very much, Madam President. It's normal in this House to thank everybody. That's what's done traditionally, and I would like to continue that tradition. But I would also like to talk about the SMEs and NGOs as well. I'd like to thank them as well, because they have played a great role in these discussions and they've influenced us greatly. I learned a great deal about a balance being struck between protection of privacy, my personal data, but also the possibility to have e-trading, e-commerce, and to have an internal market. We agree that the Directive of 95 is no longer applicable. It's outmoded now. It is split up along by 28 states, and we can't continue with that model. The risk is, however, that something that Mr. Albrecht is wanting is something that's perfect. Perhaps we need to be careful that the best is not the enemy of the good. What is feasible here? Of course, we've been working on this for 2 years now to get to some kind of parity, some kind of middle way or a golden way forward. The representative of the Council has said some very friendly words and good words, and we often blame everything on the Greeks. That's what we tend to do, and I don't want to do that, but I just want to ask him, how is he going to speed things up? We need this regulation in Europe, not just to protect privacy, but also to ensure we have economic development. What can he do to ensure that this is sped up?
Thank you very much, Mr. van der Kamp. And the next speaker is Mr. Moraes. 1 minute.
President, in the next debate on the mass surveillance of citizens, one of the key recommendations is to call on the Council to accelerate its work on implementing this excellent work by Jan Albrecht and Dimitrios Dritsas. And the reason we make this a central observation is that we spent months looking around the world at anyone who had tried to attempt to do what these rapporteurs have done. And I think, Mrs Reding, you put it very well, that members in this House have created one set of international privacy rights, but yet they have created the space for the digital economy to grow. This is an extraordinary achievement which we have put into context, and you will see that in the later debate. But we also need to create a package approach here, because it is not just about the private sector, but about the judicial and police authorities as well. It's about all of our citizens and the way that they interact with data. So we must support both parts of this, the directive and the regulation, in the package, support both of our rapporteurs tomorrow.
Thank you very much. Mrs. in 't Veld, 2 minutes.
Yes, thank you, Chair. My congratulations, first of all, to the two rapporteurs who did a fantastic job. This is a major piece of legislation of this term of office of the Parliament, and it's actually coinciding with CeBIT, one of the biggest IT fairs in Europe, which only underlines that we need this legislation as we're living in the era of personal data. I will be honest, I don't think that the data protection package is perfect. I still have doubts about some weak spots, notably the protection of data when they're transferred outside the European Union. But I will give my support to the package, imperfect as it may be, because this Parliament has to give a clear political signal that, contrary to the national governments who are dragging their feet, we stand up for the rights of citizens who have massively shown their interest in this legislation. Now, that brings me to the directive for which I was a shadow. I'm actually deeply concerned by the attitude of the EPP, the ECR and the Council. And I would call in particular on the EPP, who had the very first rapporteur, Mr. Vos, to stick to the package approach that we have agreed upon. because the directive is even more sensitive than the regulation, and I think that the opposition against it by the EPP and others is incomprehensible and irresponsible, because when our personal data are being used by the authorities for law enforcement and security purposes, privacy protections must be stronger, not weaker. In the next debate we will speak about the revelations on mass surveillance, and that only shows the urgent need for better legal protection for citizens. And finally, in a democracy, the fight against crime and terrorism takes place in a proper legal framework with proper legal protections for citizens. So not adopting the directive will seriously hamper crime fighting. So I am looking at the ECR, Mr Kirkhope was looking at the wall. If you are attached to fighting crime and terrorism, then you should vote for the directive. Thank you.
Merci, Madame Intveld. Monsieur Schlitter.
Thank you. Next speaker, Mr Schluter, for 2 minutes. Thank you very much, Madam President. 40 years ago, we saw the first piece of legislation in Sweden on data processing and protection of citizens' data. 40 years ago. It's high time for the EU to renew its legislation, and we therefore must make sure that this is adopted. I don't think that the issue is that complicated or should be that complicated before Council. What this is all about is the right to transfer data, to make a choice, to choose who should use our services. It also means that we will have a right to give our consent when it comes to the use of our data. That's what it's all about. Now, today, if you want to really read the fine print or the contract stipulations, it would take up hundreds of hours every year just to read the small print. We want to make things simpler for our citizens. We want to make sure that our citizens know about the data being stored, where it's being stored, how it's being processed. Is it being processed for a reason that is not the original one? Is it being transferred to a third party? And so on and so forth. So these are the rights we are claiming, and I think it's absolutely unacceptable for Council to block this process. Thank you, Mr Schluter. The next speaker is Mrs Ford for 2 minutes.
Of course we need to protect an individual's data, but we will also all suffer if overly restrictive data laws halt the progress of research, especially medical research. And over 50 patient organisations and medical research charities have written to MEPs about their concerns. They are warning us that the committee's changes to this new law will make many health research projects at worst illegal and at best unworkable, and particularly for large-scale projects. For example, the Million Woman study, which is looking at breast cancer and its relationship with HRT. It's this sort of project which they say would be unworkable with the specific consent regime and narrow exemption proposed by the committee. And surely all of us, including you, Ms in 't Veld, might recognise the need for further work on diseases like cancer, Alzheimer's and diabetes. Many of the committee's changes in other parts of the legislation are moving in a helpful direction, but it is vital that the changes to Articles 81 and 83 are reconsidered and expert advice is taken.
Thank you very much, Mrs Ford. Now, there is a blue card request. Would you accept it?
For you, do you accept? Yes. Je vous en prie.
Chairman, could I ask Vicky Ford whether she's making representations to her political colleague, the Health Secretary in the UK, Jeremy Hunt, about the appallingly shambolic handling of the so-called Care Data project by NHS England, whereby leaflets were just distributed like junk mail, not addressed, telling people they could opt out from having their doctor records uploaded onto a centralised database, and with no prescribed form about how they could do that. That has completely undermined trust, and that is the main threat to patient confidence in medical research. So I hope she is actually telling her party colleague how he has shot medical research in the foot with this episode.
You know, it's so good when both parts of the coalition work together to correct wrongs. For your information, I did spend all day yesterday, on Friday, with the Minister responsible for research and getting this bit of regulation right so that there is a balance between protecting data but also allowing all of us to benefit from world-leading science that needs to look at how patients and people are affected. That is a really important balance, and yes, our side of the coalition is working on correcting that wrong and getting it right.
Merci. Nous ferons le débat.
Thank you very much. Well, perhaps that's a debate you could have in the House of Lords. Mrs. Ticau, you're actually on the list of speakers, so you can speak later. And I now give the floor to Mr. Coelho.
Thank you, President. Minister, ladies and gentlemen. We're living in times in which the value of protecting the individual's data as a question of human rights is increasingly obvious. It's quite astounding the quantity of personal data which are stored on our personal details, the music we listen to, the friends we know, what we buy, the money we spend, etc. What is a scandal is that we've seen the security agencies in the member states and friendly states infringing this right to data protection and privacy. European citizens have every reason now to call for proper protection of their private data so that their rights and liberties can be properly safeguarded. I would like to thank Mrs. Reding for the proposals she has put forward, which have now gone into the European Parliament resolution of 2011. And I also think it is right that we are now going to have a regulation and a directive. But the results we're going to achieve will be far from perfect, but they are a step in the right direction. I hope that the Council does not challenge the fact that we are using a regulation or proposing the use of a regulation here so that we can add legal security, safety and clarity to the situation as regards citizens' rights and their right to protection as regards their data. Thank you very much.
Thank you, Mr. Coelho. Mr. Lopez Aguilar is the next speaker. Thank you very much, Madam President. In this debate, we have talked about our new standards, the ones that will be put to the vote in detail tomorrow, and we're also talking about the digital revolution. This is why the Directive of '95 is now completely obsolete. That has been recognised. But what about the enormous digital step forward that this European Parliament is making in terms of regulating the fundamental rights of our citizens? That's what it's really about, the fundamental rights of our citizens, and what's in the Lisbon Treaty, in particular in Article 8, the Charter of Fundamental Rights as well. This Parliament is not just talking about, transport of live animals or about the marketing of food products. These two are important, of course, but here we're talking about fundamental rights. And I think we really are talking about protecting the privacy of our citizens, about their right to consent, and we're also shoring up the principle of legality. It's important to make sure that our citizens have rights when it comes to their privacy, their private data, and it's important that any measures taken are proportional in nature. This is in accordance with the Charter of Fundamental Rights in the EU. In addition to which, we're also talking about making sure that we have the opportunity to rectify or to erase data as citizens if needs be. The right also to be forgotten is enshrined in this piece of legislation. So it's a gigantic step forward for the European Union with a regulation, with the involvement of the fundamental rights principles. It is very important for us to make sure that citizens have the right to go before the courts in our member states. In addition to that, of course, we have a directive. The two form a package, if you like, and we would like to draw your attention to the issue raised by the rapporteur earlier on. We need to make sure that we have certainty, that we have security in this field, and that is why we also need this directive for the law enforcement agencies. That needs to go hand in hand with the regulation. Thank you, Mr. Lopez Aguilar. Mr. Shogor for 1.5 minutes. Thank you very much, Madam President. I would like to express my agreement with the Commission proposal. I think it's very important for us to look at the transfer of personal data, make sure that our regulation is in place for that. Now, we know perfectly well that if we want to prevent things from going wrong, we need to make sure that we look at this very closely. We're talking, after all, about the fundamental rights of our citizens, and that's why the transfer of personal data is of such importance in this context. There are a lot of technical developments in this day and age, and this is why the protection of personal data has become a completely different affair in this day and age. We're talking about a different reality. We're talking about the sharing of data on an unprecedented scale. And, of course, we need to bear in mind that it's important to prevent commit crimes. It's important to fight that struggle as well. That too needs to be regulated. But at the same time, we are talking about the fundamental rights of our citizens, and they need to be strictly protected. I am absolutely convinced that the European Union should be in the forefront in this fight on a global scale. And I very much hope that this piece of legislation really will reflect what we want in Europe on this particular subject matter. Thank you.
Thank you very much indeed, Mr. Sogor. Mrs. Țicău, please. Thank you very much indeed, Madam President. I support the suggestion of having this legislative package on protection of personal data so that there will be more flexibility and a reduction in bureaucracy, and there will also be a series of common rules when it comes to dealing with personal data and the freedom of movement of this data. And I support the idea that there should always be an explicit form of authorization from the person who is the data subject. And I also think it's very important that we should inform the competent authorities so that there is proper treatment of each of the transfers of personal data. And I also think that this notification should come within 17 hours of the data subject having been informed that they will be their personal data will be used. And I also think that the use of personal data should be the responsibility of the operator, which should make sure that there is proper processing of this personal data of the data subject. Thank you very much. Thank you very much. Mrs. Corazza-Bildt, 1.5 minutes.
Chair, Madam Commissioner, with this important reform, we increase personal data protection, overcome fragmentation between member states, and provide legal certainty. This regulation concerns every aspect of our life, affects both consumers and companies, the way we access goods and services, communicate on social media, marketing, how we get information and book travels. That is why I have been driving to make it applicable in real life, with clear definition of consent and profiling, technological neutral and future-proof. We succeeded in striking a balance between higher standards of privacy, public access to documents, and freedom of expression. I'm happy that my proposals to protect children have been included. Information should be child-friendly and easy to understand, because teenagers may be not aware of the consequences and just click it away. To verify consent, the industry should take its share responsibility. However, Madam Chair, there are still issues that need to be improved. The current definition of sensitive data may affect the Swedish Health Register, and unless further exception to the right of erasures are done, medical research will be hampered. We also need to cut red tape for companies to really make sure that development of innovation and a competitive digital single market can blossom. Together we should move fast in implementing the negotiation with the Council and improve the regulation to make it even more applicable. Thank you, Madam Chair.
Thanks very much indeed. Mrs. Țicău, you've already used your blue card and you've had the floor twice already. Mr. Zaleski, is it because you want to be in Catch the Eye or a blue card quest? Well, actually, I have a question for Mr. Aguilar, but I wasn't seen. Please look around the chamber properly. We shouldn't discriminate against people, but I do nevertheless wish to be written in for, or written up for Catch the Eye as well. Very well, Mrs. Regner, please, 1 minute.
Thank you, President. Commissioner, I'm very concerned about data protection, and I want to focus particularly on the processing of data. Now, Article 82 covers minimum standards for the data protection of workers. This is particularly important for things like collective agreements. Other areas covered in the directive is the explicit ban on any blacklisting. In the past, we've learned about shocking examples in practice where a difficult, in inverted commas, worker is put on a blacklist and then ends up without a way to earn a living. This won't do in the future. in our report, we propose sanctions for this kind of thing and a continued explicit ban. There are other points which I find less than felicitous. No involvement in determining the data protection officer, but nonetheless, in terms of the protection of data workers, this is a definite step forward.
Thank you very much, Mr. Iacolino. A minute and a half, please.
Thank you very much, President, Commissioner Reding, Council colleagues. There's no doubt that in terms of consumers and families, this will bring a lot of benefits. The provisions from 1995 are really not up to the challenges of today. In 20 years, everything has changed in this area. The modernization which has flowed from the internet has changed the parameters of this debate hugely, and this is why we welcome the recommendations here today. In the wake of Datagate as well, there has been a lot of consumer mistrust, and this again militates in favor of better legislation which gives better protection to citizens, companies, families and every individual. It's essential that we do this if we can really hope to create a one-stop shop, a single digital market in the European Union, and if we can really aspire to create one which will benefit SMEs, benefit individuals and will protect those who are vulnerable. We also have to establish parity for European companies with non-European companies operating here. And these pieces of legislation which are proposed here today will enable us to take the necessary steps forward. We'll be able to guarantee the necessary protection of privacy whilst at the same time ensuring that essential data can be collected. We'll be protecting fundamental rights and guaranteeing safety and security for our citizens. Thank you.
Thank you very much. We'll now move on to the Catch the Eye procedure, and I'll give the floor to those who've asked for the floor. Mr. Zaleski, first off, please.
Merci, Madame la Présidente. Alors, on a trouvé une
Thank you very much, Madam President. We found a good solution there, I think.
który zajmuje się między...
Let me speak in my capacity of a psychologist, and I'm dealing with issues such as privacy, and protection of privacy is one of the fundamental reasons we behave. Freud would actually agree with that statement. But people do have common sense. And for scientific reasons, for example, in search for better treatment or to defend ourselves against some terrorist attacks, some people are likely to divulge information. We must find some sort of hammer out some sort of a balance. Either we divulge nothing or everything. Some psychological approach will probably be necessary. And I leave it to your wisdom, Commission, and also to other MEPs. Merci beaucoup.
Thank you very much, Mr. Zaleski. Mr. Tarabella. 20 years today, but that doesn't give you any extra time on the microphone, I'm afraid. Thank you very much, Madam President. Commissioner, finally citizens are going to be responsible for their own personal data. It's like a dream that's finally come true. And sometimes safeguards are put in place to protect European citizens, and that can only be a good thing. Some problems, though, some colleagues here in this chamber have made it impossible to continue with the Snowden lobby, which I think would have been very useful. Then there's the NSA and their incursions on private lives. We're going to talk about that in a moment. But some people just want to ignore this. I'm talking about multinationals here being championed above citizens. The text that we're going to vote on tomorrow means that certain things won't be considered to be personal data and won't be covered by the text. Some people in Belgium have said that the number of complaints on violations of this kind has doubled in a year. The NSA has been carrying out espionage for large multinationals and to help them with their marketing, but it's up to European citizens now to fight back. Thank you. Mr. Tomajic, please.
Pardonnez-moi, Madame Tomazic, j'ai dit Monsieur.
I'm sorry, I meant Madam.
Zaštita osobnih podataka veliki.
Personal data protection is a huge challenge today. Citizens are targeted by aggressive marketing campaigns directed at them based on their personal data, which is used by marketing agencies agencies without their will and consent. This kind of data leakage doesn't usually come from government authorities and institutions, but many citizens have other concerns directly linked to the state. Many of our citizens are reluctant to accept increased surveillance, and are afraid of a possible unauthorized and unfounded use of the repressive apparatus and the secret services to limit their civil rights. In spite of this, my concern is that this proposed directive would significantly encumber the work of law enforcement bodies because banning the divulging of data about ethnic and racial origin and religious affiliation will be an obstacle to investigating and processing war crimes and terrorist attacks, as these elements are often the main motive of these crimes.
Die geltende Datenschutzrichtlinie weist.
Thanks very much. There are a lot of gaps in the data protection legislation, and fortunately, though, it's been implemented in different member states. There are a number of questions coming to where the activities took place and then whether the data was collected. Now, these gaps are used by private companies in the USA, and they set up subsidiaries in Ireland. So we've got to close these gaps. The rules must be applicable to data processors in third countries if they're dealing with European data, and we need to change the legislation on data processing so that those concerned can consent or not. Now, there are a lot of delegated acts here, and that's not good, but it doesn't help for legal security, and we need sanctions which generally deter, otherwise this will be toothless. Thank you.
Thank you very much. Mrs. Silvia Costa, please.
Grazie Presidente. Per costruire...
Thank you very much, President. In order to create a European space where there is protection for personal rights, it is important for us to adopt these two integrated proposals, because we need to make a whole range of new rights effective, and we need to protect everybody, including young people, in terms of the internet and the digital era. It's extremely important that we recognize that the scope of this directive and this proposed regulation is transnational too. It applies within the European Union, but also beyond the boundaries. And I hope that the Italian presidency will give us a commitment that it will try to accelerate the implementation of these proposals, because it is absolutely essential that we do this. Thank you.
Thank you very much. Mr. Piccola, please.
Ovu raspravu vodimo dok još od...
We are conducting this debate at a time when there are still affairs where privacy has been threatened. It's been 20 years since this legislation was enacted. We have to keep up with the times and take into account the development of a social network and the storage of data on external servers. This affects everyone in the EU, but also those outside the EU using personal data. We have to make sure that the procedures in different countries are harmonized. We need to pay special attention to the protection of children, and there has to be control over the amount and scope of information provided. And especially if...
Thank you, Mr. Piccola. That brings us to the end of our Catch the Eye procedure. Madam Commissioner, you have the floor.
Thank you, Chair. Let me take one or two technical questions before I come to the conclusions. Concerning SMEs, some parliamentarians have raised their concerns if the SMEs are well protected. Well, I say that this reform is good for the SMEs, because for those SMEs who do not act across borders, we have included a risk-based approach for data protection, which makes sense, because the safeguards the company has to apply have to be proportionate to the risk for data protection. And for those SMEs who want to go cross borders, the reform opens the market, At the moment, the fragmentation of the European market prevents the SMEs from applying the rules in every territory they want to develop their business, which could make 28 authorisations, 28 different laws to apply. So in order SMEs and start-ups to be capable to utilise the whole of the European space, this reform opens that space for them. It is estimated to make a saving of €2.3 billion for these small companies, most of them. Some parliamentarians have raised also the question of health. I do not want to go into party polemics on this, but let me just underline that the Commission proposal includes specific rules on data processing in the area of health. It provides that in very specific research circumstances, data can be processed without the consent of the individual concerned. This very specific rule is justified, in my view, because of the crucial general interest medical research brings to the society. So I believe that the Commission's proposal should be maintained in this point, as it is striking the balance between protecting citizens' rights in a very delicate domain and facilitating the indispensable research which saves lives. And I hope that the negotiators in the trilogue will find an equilibrium in this field which can please all those who want to preserve the individual and who want to preserve the research. Concerning the directive, we should never in this House forget that freedom and security of our European citizens are the two sides of the same coin. They are two policy objectives that should be followed in parallel. One cannot go without the other, and one should not eliminate the other. That is why the Commission answered the European Parliament's call to present a reform that would apply to the private sector as well as to the law enforcement domain. And I do believe that in the light of the NSA spying revelations, European citizens are more concerned than ever about the risk of abuse, of invasion of privacy by institutions sometimes hiding behind security considerations. Law enforcement is not over and above the law. And by the way, speaking about directive and framework decisions, this House must know that the framework decisions will automatically, on the 1st of December this year, become directives. And for this change we do not need a parliament. And I hope that the European Parliament will go a step further than the soon obsolete intergovernmental method of pre-Lisbon times. That is what the Parliament should do, and that is what I am pleading for. And that is, I think, also what the citizens would like us to do. The citizens won't understand why a Parliament could oppose a directive which would protect the citizens in the law enforcement domain. And that is why tomorrow I would like really to see a strong vote and a united Parliament backing both proposals, the regulation and the directive. Ladies and gentlemen, honourable parliamentarians, tomorrow's vote must bring us closer to ensure that the European Union remains the gold standard setter for data protection worldwide. And it should give the European Parliament's negotiators, who need to sit down and speak about every detail with the Council, a strong mandate for the future negotiations. And it should make crystal clear that for Europe and in Europe data protection is much more than just a concept or a vague principle. Here we are speaking about a fundamental right, and we should back a fundamental right by a fundamental law. And in this sense I congratulate the European Parliament for its strength and for its ambition. Let us not discuss about details, let us see the fundamental right question, let us go for it. European citizens expect nothing less and deserve nothing less.
Madame Reding.
Thank you very much indeed, Madam Reding. I'd now like to give the floor to Mr. Kukulas on behalf of the Council. So, strong demands have come in. I hope that progress has been made.
I think in my opening remarks I explained the reasons why it has not been able or possible for the Member States, for the Council, to make more rapid progress as everybody would have wished. During the Greek presidency, our presidency, which is running its 10th week, as I said, we have already organised 10 meetings of the relevant working group. At the informal ministerial meeting in Athens on the 23rd of January, there was clearly an overall support for the approach of Chapter 5 on international data transfers and Article 3 on the territorial scope of the regulation. And this support has been confirmed at the Council meeting last week. I agree with the rapporteurs and also with the Vice President of the Commission that the Union must take the lead in this in the development of the legislation on data protection. While working on this file, of course, we have also to make sure of the high quality of the legal framework in order to meet the challenges posed by the rapid changes of information and communication technology and ensure the high level of protection of fundamental rights, as it was rightly mentioned by Vice President Reding. She also added, and I want also to underline, the growth dimension of this proposal, of this package for the SMEs, but also for the integration of the internal market. So for all these reasons, the Greek presidency is committed to progress this file. I am sure that the Parliament and the Council will be able to bring this file to a successful conclusion with all our support. We are determined to push for conclusion. Our aim for the time being is to have a positive conclusion, at least partial on some, so that we can start the trilogue by the end of June. Thank you for your attention.
Thank you very much. Now for the two rapporteurs. Mr. Drutsas, please, 2 minutes.
Thank you very much, Madam Chairman. And may I also thank colleagues for the comments, the good words and also the support. And I have always also noticed with some satisfaction, I can say, that all interventions today have reaffirmed the package approach and its importance. May I express the hope that colleagues will confirm this also with the vote tomorrow. After all, it is about our credibility, it is about the credibility of the European Parliament vis-à-vis the European citizen. So may I once again appeal to colleagues to vote tomorrow in favour of both reports, regulation and directive. Of course, I will follow what some colleagues have said, for instance, Sophie in 't Veld or Carlos Coelho. The package presented is not perfect, this is clear, but it is the right step into the right direction, and this we should take into consideration. And most of all, it will be the necessary and important message to our citizens that we are taking the concerns very much into consideration, especially in such difficult times, sensitive times, after the NSA scandal and all the other revelations. But our vote tomorrow will also be the necessary message to the Council and to Member States to speed up with their preparations and come to the trilogue so that we can finalise this package and can present to our citizens a real and good reform of the data protection package. Thank you very much once again.
Thank you. Mr. Albrecht, to wrap up, please.
Colleagues, thank you for this good debate. I would like to thank all the colleagues who took part. In my final remarks, I would like to address some concerns, or I would say misunderstandings, which seem to circulate. First, we do differentiate clearly small and medium-sized enterprises from bigger businesses. There are quite a lot of lightening points which are lightening the burden for SMEs. But we also have to change a bit of the approach when it comes to data processing. Because it's not only the size of a company which might count, but also the number of personal data being processed in a company. And that's what we try to do in our compromise when it comes, for example, to the data protection officers or to impact assessments. It's the risk which counts, and that we took into account. Secondly, some publishers and journalists organizations fear that this regulation would make their work as a journalist more difficult. That is not at all the case. The existing data protection law already provides for reconciliation of data protection and freedom of expression by the member states, which is exactly what we ensure in Article 80. Nothing will change for journalists in this regard. And the same, by the way, is the case for other special professions, for example, when it comes to researchers and archives. By the way, with regard to health research, it's clear that we make an exception. We say for high public interest, there's an exception. You don't need to have a consent. But health data is a sensitive case, and we cannot just allow people to run into doctors' offices to take our personalized private profiles in any case. So it needs to be reconciled, and that's what we try to do. Third and last point, some few member states raised the fear that this regulation would replace the rules which decide if personal data can be processed by public authorities. That is also not the case. On the contrary, this regulation even states explicitly that there have to be member states' laws for the data processing of public authority, and that is why the regulation doesn't say which data can be processed by tax authorities or schools, but the member states have to say it. So after all, this is a good, proportionate and strong compromise, and we hope that we can start negotiations with the Council directly after this Parliament has been reconstituted and you have found your position in Council. Thank you very much.
Thank you very much, Mr. Albrecht. Mr. Voss, did you wish to speak? He's left, has he? No. Sorry, I didn't see you earlier on. Perhaps you had a blue card procedure? You had a question perhaps for one of the two rapporteurs? I don't know, but please go ahead with your question now if you wish. You have the floor.
Vielen Dank. Ich hatte eine blaue Karte.
Thank you very much. I had a blue card that I wanted to ask a question of Mr. Drutzes, and this is because, not least after what Ms. Inetfeldt said, there was an awful lot of mention of packaging and participation in the decisions taken under the directive. Now, a particular group should not be allowed to determine excessively what the shape of the report is. I'd like a comment on that.
Thank you very much. Mr. Drutzes, please, a quick response from you.
Ich muss ehrlich gestehen, ich bin sehr, sehr...
Well, thank you very much. I'm surprised, really, to hear what you're saying. We've been working for 2 years together, all of us, on the regulation and the directive. So it seems strange to be suggesting that the wishes of any particular group have not been taken into account. I think this particularly because no specific proposals have been made in terms of the directive. To some extent, it's just been a question of trying to delay progress because of the wishes of some governments. Thank you.
Yes, thank you. I think that brings us to the end of that debate. So that's the end of the discussion, and we've got a vote on this tomorrow at 12. Now we've got two linked reports. First of all, we've got Mr. Murray's report on the NSA surveillance programme, and I'd like to give him the floor now as rapporteur. Please, sir, you have the floor.
Pour 4 minutes.
For 4 minutes.
Thank you, President. When we began this inquiry 6 months ago into the revelations of Edward Snowden and the campaign of the Guardian newspaper, this was an extremely difficult and sensitive and ambitious inquiry that we had to conduct. The precedent we had was the Echelon inquiry, the CIA renditions inquiry, and we had a huge task on our hands. But what was important about the inquiry was that it was different, and the narrative was different from any inquiry undertaken by any member state because of what we have just heard. And what we have just heard is that the European Union is unique, and this House is unique, in that we were a mature parliament which was already legislating on the data protection regulation and the directive. So we were a parliament that was already dealing with one set of privacy rights internationally, and we were dealing with the digital economy. So while the Snowden revelations were raging, we were already equipped to deal in this House with privacy rights and the whole area of data protection law. And what I tried to do with my colleagues in this inquiry was, given that we only had 6 months and we had an extraordinary set of sensitive issues to deal with, was to take Edward Snowden's revelations, and he has given evidence in the last few days, all of the sensitivities around the spying allegations and espionage, all of that and the many stories in the press, and to ensure that from that situation that we work together across the political groups to have the most in-depth inquiry, I believe, anywhere in the world. In 6 months, we ensured that we went to Washington, that we ensured that we had accountability here amongst whistleblowers, parliamentary scrutiny bodies, intelligence bodies, a whole range of players and actors here in Brussels and Strasbourg. And we ensured at the end of that process that amongst my shadows, and I do want to mention all of them, Mr Voss, Mrs in 't Veld, Mrs Ernst, Mr Albrecht, Mr Kirkhope and our colleagues from the AFET committee, all of us who worked tirelessly over those many hours to ensure that at the end of that process of the Snowden revelations and many hours of interviews, that we looked into what intelligence services were doing, but we also understood that we had to come up with a digital Bill of Rights. And it's a testament to this report that in many parts of the member states across the European Union, many political parties and in many member states, the issue of the digital Bill of Rights and a digital habeas corpus is being spoken of. They are in fact referring to our report, and in doing so they're referring to what we learned from in the Echelon report, was that we can carry out an in-depth inquiry in this House, but we must make something of it, and we must make something lasting of it. There is so much expertise and commitment here in the European Union on issues of privacy and fundamental rights, but how do we make it last? So what we have created from the Edward Snowden allegations, what we have created from the witnesses and interviews, Jim Sensenbrenner, the congressman who created the Patriot Act but told us now that we need to do something about what the NSA is saying, President Obama, who told us that on the one hand he wants to protect US citizens but foreshadowed what is happening to foreign persons. In all of that, we had to create this digital Bill of Rights, or digital habeas corpus. And so we created a number of actions. First of all, to conclude the EU-US umbrella agreement, guaranteeing fundamental rights of citizens to privacy and data protection, to suspend safe harbour until a full review has been conducted and current loopholes are remedied, to ensure that we suspend TFTP until the umbrella agreement and negotiations have been concluded and a thorough investigation has been concluded on the basis of an EU analysis, to evaluate any agreement, mechanism or exchange with third countries involving personal data in order to ensure that the right to privacy and to the protection of personal data is not violated due to surveillance activities, and to take the necessary follow-up actions. I'll finish in just 30 seconds. to protect the rule of law and fundamental rights of EU citizens, including threats to freedom of the